Hello and welcome to the Arbitration Conversation. So as you know, we are rounding out, we are headed to episode 100. And this in fact is episode 100. So we're really pleased. We have a very, very special guest to talk about a really important issue in arbitration. We have Chairman Bobby Scott. Chairman Scott, from the great state of Virginia. He has been in the House of Representatives since 1993. Not only that, he's the first African-American elected from Virginia since the Reconstruction, and only the second in history. Not only that, but he's done a great deal for education and labor, and he is currently the chairman of the Education and Labor Committee. First of all, thank you so much for taking time out of what I know is a very, very busy and hectic schedule.
Well, thank you, Amy. It's good to be with you.
Well, this is a really important hot button issue. Following arbitration in this whole series. Of course, we're looking at it from all different angles, and it really matters, you know, the type of case you're talking about and whether or not arbitration works, doesn't work, and what the issues are with it. I'd love it if you could tell us a little bit about the Restoring Justice for Workers Act and what that has to do with arbitration.
Well, the Restoring Justice for Workers Act essentially prohibits arbitration, forced arbitration in employment contracts. You can, if you want to go into arbitration, that's fine, but you can't be forced. The problem with forced arbitration is that in many cases, the employer has all the power. It's not like you have two equally powerful parties negotiating. One has all the power and one is stuck with negotiated with being on the territory pretty well controlled by the employer. The arbitrator who comes in is really at the mercy of the employer. If he wants to be called as an arbitrator again, he's not going to have a very good chance at that if he's not ruling in the employer's favor. And that becomes unfair. I mean, the chance that the employee is going to be calling the arbitrator, he didn't know these people. The employer does. And so if you've been ruling nicely, the employer knows who to pick. The employee, is just guessing. And so you have a pretty well a stacked deck making the decision when you go into forced arbitration. There's no incentive to make it fair if it's forced. I mean, if the word gets out that these aren't fair proceedings, if you have some choice in it, you're not going to choose it. But if it's forced, there's no incentive to make it fair. And so
talking a little bit about the bill and how it applies. Yeah, so of course, looking at, pre-dispute arbitration agreements versus post-dispute arbitration agreements. How would this act impact pre-dispute and how would it impact post-dispute arbitration?
Well, if it's forced arbitration, you have to go through it before anything else happens. And you may be bound by, depending on how they word the thing, you may be bound by the results. If you have a choice, first of all, the process would have to be fair, but you would have a choice to go into court and vindicate your rights with a fair judge and jury. One of the clauses that's often in these forced arbitration agreements is that they have to be individual cases, that you can't have class actions. Many of the activities affect a lot of people, a little bit. And so, if you have a claim of a couple $100, it's just not worth it to go into any kind of legal proceeding over a couple $100. But if you have 1,000 people who are similarly situated, and you can show the pattern that everybody is similarly situated, being ripped off, then it's much more likely that you're going to be able to hire a lawyer on a contingent fee who will be willing to take a portion of the proceeds as a fee so that you can actually have your case heard. With the combination of forced arbitration and an individualized case, the employer is really getting away with whatever he's doing. There are cases where what's called wage theft, where you're not paying the appropriate overtime or minimum wage. And if you can show you're doing that to everybody, then everybody ought to be able to come in one case. If you've got forced arbitration without any ability to bring essentially a class action, each one has to sue for a couple of $100. But,
Right.
that's not going to happen. So the employee gets away with it, and that's the problem.
Yeah, I mean, we look at sort of, I think a lot of the reasoning right behind including arbitration clauses in sort of employee manuals and in different ways is probably to stop class actions. So what about those that argue, well, wait a minute, don't class actions just help the attorneys? What do we say? What do we think about that?
Well, Medicare only helps the doctors.
Right.
So
Well,
since the doctors are the only ones getting the money, then why do you have Medicare? No, the lawyers are providing a service to their clients. And the fact that they get paid, that's true, they get paid, but the client gets the benefit.
yeah.
And when you have a situation where a client is getting ripped off and he hires a lawyer, and a lawyer makes some money vindicating the rights of the employee, that's a good thing. The fact that the lawyer gets paid is not necessarily a bad thing, because otherwise the employee can never have his rights vindicated.
Right. I mean, one of the things I talk about with students is explaining sort of the private attorney general function, really, of class actions, because you can sort of shine a light on an issue that maybe the attorney generals wouldn't have enough time or bandwidth to take care of. I wonder another piece that comes up in employment and talking about this new law and the proposal, of course, bill, privacy. How does privacy and sort of non-disclosures, why is that important, or is that an issue in arbitration?
Well, in non-disclosure agreements have a sinister effect where the employer is found guilty and pays off and continues to do it because nobody knows that he's been caught. Nobody knows that the crime is occurring. Nobody knows that their overtime isn't being paid. Once the settlement or the judgment is public, that they ripped somebody off in overtime, everybody's going to be checking their pay stubs. Well, I didn't get mine either. But without the disclosure, nobody knows.
Yeah.
And so the non-disclosure agreements, really, unless there is some overriding reason for the privacy, only serves to allow the employer to get away with it again.
And I had also posted and made people aware of the hearings on November 4th. Are there going to be any more hearings, do you know, that will be on the arbitration issue? I think there's one today as well. I don't know if your committee is going to have any more hearings on arbitration coming up.
Well, there may be others. There's several committees that have jurisdiction. Our committee has jurisdiction over employer contracts. Judiciary has jurisdiction over a lot of other contracts. Oversight, government reform and oversight has jurisdiction over federal employees and what can happen there. So there are a number of committees that have jurisdiction and have been looking at the issue and recognize how unfair it is to employees to deny them their right to vindication in a court of law if necessary, or to band together with identical cases to amass enough of an amount in controversy to be able to afford a lawyer. You're not going to court over a couple $100. And if you got 1,000 people being ripped off just a couple $100, you just get, the employee gets away with it.
Yeah. Well, and sort of the multi-million-dollar question is, what do we think? Where is it in the process? And what's the likelihood that this will become law?
Well, I think that there's several bills being considered. One, overall ban and forced arbitration, another ban and forced arbitration in sexual harassment cases, another in employment cases. And so we'll look and see what can be passed. Different committees are considering the different bills. So we're in the process now of considering what can pass. Hopefully something will, so we can set the precedent that forced arbitration is a bad thing.
And it's so important. We talk a lot in I teach a class that's called lawyering and problem solving. And really the key should be, how do we solve this problem, right? And certain mechanisms are just not right for solving a problem. And so when we think about employment disputes and the importance of, like you said, banding together and getting the word out so people know what's happening, this is really important law. So I'm so thankful I know how busy you
The
are.
arbitration could be a good alternative, but it should not be forced.
Right. And that's the thing with the post dispute, because this bill would not prevent, so me as an employee, I could still enter into a consensual post dispute arbitration agreement.
Yeah, if it's voluntary, but the real mischief comes when it's forced and binding. And when you don't have people really negotiating, and when they hand you your contract and you have to sign it, and it includes a forced arbitration clause, you really didn't have any choice. And so that's a real problem. If you chose on an individualized basis to go into arbitration, that's fine. If you had the alternative to go to court, and people will find out, I went to arbitration and it wasn't fair. The word will get around, and you'll go to court, and you try to get a large group together so you can combine, so you'll have enough money and controversy to be able to hire a lawyer. And it can work, but not if it's forced arbitration where the employer has all the cards.
Right. One more point that people don't think about is, a bill like this is going to have no impact on mediation. So that's okay if somebody wants to enter into a consensual, non-binding mediation to help sort of vent and air out your concerns in a manner that is comfortable to you. Again, if it's consensual, consent being sort of the key there. So this isn't ending all arbitration at all. Well, listen, thank you so much. Again, we're going to keep our eye on this bill, see where it goes, as well as, of course, the FAIR Act and other laws that are being proposed with respect to sexual harassment, as well as you said, on arbitration. Thank you, Chairman Scott. We're just honored that you are our 100th episode. So thank you so much.
Well, thank you. I enjoyed it.